Good afternoon, ladies and gentlemen. Welcome to the Public Service Commission of South Carolina. Today is January 27th. It is 2 p.m. Please join me in a brief moment of silence. Thank you. We're here today for our agenda meeting. Before we begin our meeting, please, let's take roll. President in hearing room, we have Commissioner J. Williams, C. Williams, Powers, and Belzer. Joining us virtually, we have Commissioners Caston, Thomas, and Urban. Attorney Butler, if you would, please read the agenda.
Yes, sir. Thank you, Mr. Chairman. Good afternoon, Mr. Chairman, members of the commission. The first item of business would be to set the next commission business meeting. Staff would recommend that be set for February 3rd, 2022 at 2 p.m., which is a Thursday.
That will be our next business meeting. If you would, please continue and call the first item.
Yes, sir. Be glad to do so. Going to the utilities agenda, item number 1 is the request of True Vista Communications Incorporated and Time Warner Cable Information Services, LLC, for approval of the adoption of an existing interconnection agreement.
All right, is there a motion?
Chairman Williams, Commissioner Caston, I'd like to make a motion.
All right, Commissioner Caston, you have the floor.
Vista Communications Incorporated and Time Warner Cable Information Services, LLC, for the adoption of the existing interconnection agreement between True Vista Communications Incorporated and South Carolina Telecommunications Group Holdings, LLC, doing business as Spirit Communications. I so move.
Hearing Commissioner Caston's motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
Mr. Chairman, I didn't hear the first part of the motion. It was like the video froze, and I hate to ask this. I think he was moving when he said I so moved, but could we ask Commissioner Caston to restate?
Commissioner Caston, if you would, please restate your motion, sir.
Yes. I move that the commission approve the request of True Vista Communications Incorporated and Time Warner Cable Information Services, LLC, for the adoption of the existing interconnection agreement between True Vista Communications Incorporated and South Carolina Communications Group Holdings, LLC, doing business as communication.
Thank you, Mr. Chairman. I vote aye.
All right, thank you. Commissioner Caston?
Aye.
Commissioner Urban?
Aye.
Commissioner Thomas?
Aye.
Commissioner Powers?
I vote aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 2 is in docket number 2022-2-E. This is a petition to intervene out of time, in this case, filed by the South Carolina Energy Users Committee.
I beg your indulgence, Attorney Butler. Give me 1 second.
Mr. Chairman.
All right, thank you, Attorney Butler. If you would, please reread that item for us.
Yes, sir. Be glad to do so, Mr. Chairman. It's docket number 2022-2-E. This is the annual review of base rates for fuel costs for Dominion Energy. We have for commission consideration a petition to intervene out of time filed on behalf of South Carolina Energy Users Committee.
All right, is there a motion?
Mr. Chairman.
Commissioner Powers.
Thank you, Mr. Chairman. I move that the commission grant the petition to intervene out of time filed by the South Carolina Energy Users Committee. I believe that granting the petition at this point would not prejudice the parties, nor will the proceeding be delayed.
Thank you. Thank you, Commissioner Powers. Hearing Commissioner Powers' motion, is there any discussion? Hearing none, we'll vote, starting with District 1. Commissioner Williams,
Aye.
Vice Chair Belzer,
Aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, we have two motions for admission pro hoc vici in item numbers 3 and 4. Staff recommends that these be taken together. They're both in docket number 2021-349E. The first one is the application of Christina D. Kress, Esquire, for admission pro hoc vici. And item number 4 is the request of Kamal O. Robinson for admission pro hoc vici in the same document.
All right. Those items will be carried over.
All right, sir. Thank you. Item number 5 is in docket number 2016-414E and 2022-17E. We have the request of Dominion Energy South Carolina Incorporated for approval of a contract and 2 amendments to contracts for electric service between itself and Mercedes-Benz Vans LLC, along with a request for confidential treatment of certain portions of the contract documents.
Is there a motion?
Mr. Chairman.
Commissioner Powers.
Thank you, Mr. Chairman. I move the commission grant Dominion Energy South Carolina Incorporated's request for approval of contract number E7021048 for electric service, Second Amendment to contract E7016018 for electric service, and the Third Amendment to contract number E7008010 for electric service, all by and between itself and Mercedes-Benz Vans LLC, along with the request for confidential treatment of certain portions of the contract documents.
Thank you, Commissioner Powers. Hearing Commissioner Powers' motion, is there any discussion? Hearing none, we'll vote, starting with District 1. Commissioner Williams,
Aye.
Vice Chair Belzer,
Aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 6 is item ND 2022-1-E. For consideration before the commission today is Dominion Energy South Carolina Incorporated's request to open an informational docket pursuant to order number 2021-570, issued in docket number 2021-25E regarding stakeholder meetings.
Is there a motion?
Chairman Williams.
Commissioner Williams.
Thank you, sir. I move that the commission grant Dominion Energy South Carolina Incorporated's request to open an informational docket pursuant to order number 2021-570, issued in docket number 2020-125E, regarding the stakeholder process to examine an electricity affordability program for Dominion Energy South Carolina's low-income customers and related issues. I so move.
Thank you, Commissioner Williams. Hearing Commissioner Williams' motion, is there any discussion?
Yes, sir.
Commissioner Williams.
Thank you, Chairman Williams. This is the beginning of the fulfillment of the stipulation from the Dominion rate case last year. In that stipulation and the following order, Dominion Energy agreed to investigate a program providing for electricity affordability for low-income customers. A stakeholder group has met once and heard a presentation on a Dominion Energy Ohio percentage of income payment plan. I appreciate the path that this docket takes for Dominion Energy and its customers. Affordability of energy coupled with demand-side management and energy efficiency are key programmatic opportunities for South Carolina's rate-paying customers. I look forward to seeing the programs that may emerge from this process. Thank you.
Thank you, Commissioner Williams. Is there any further discussion? Okay, hearing none, we will vote, starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers?
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 7 is under docket number 2021-291A. Staff is presenting for commission consideration issues related to the pre-filing of surrebuttal testimony before the commission.
Is there a motion?
Mr. Chairman,
Commissioner Powers, you have the floor, sir.
thank you, Mr. Chairman. The allowance of surrebuttal testimony to the commission has been questioned in recent months and is one of the matters on which the commission recently sought comments by parties appearing before the commission. Comments were received on the subject, both pro and con, and these have prompted me to make this motion before the commission at this time. Rebuttal testimony is a matter of right. However, surrebuttal testimony is discretionary as stated by the South Carolina Supreme Court in the case of Palmetto Alliance versus South Carolina Public Service Commission. Surrebuttal testimony must be viewed as somewhat different from other testimony because if presented, it comes at a point in a proceeding where the parties have submitted their direct exhibits and have also had an opportunity to respond to the other party's testimony and exhibits. The theory and purpose of surrebuttal testimony is to respond to any new matters brought up by the moving party in its rebuttal testimony. However, if rebuttal is limited to responding to other parties' direct testimony as intended, then surrebuttal testimony should rarely, if ever, be necessary. That is why historically surrebuttal testimony has only been presented as deemed necessary in the discretion of the commission. To the extent that the commission believes the privilege has or is being abused, I believe that the commission has authority to curb such abuses by limiting the scope of presentation of surrebuttal testimony on a case-by-case basis. I also believe that potential for such abuses may be limited in the same manner. Accordingly, I move that the commission adopt the following procedures effective today. When developing the procedural schedule where pre-file testimony is anticipated, the commission's clerk's office shall establish a deadline wherein an appropriate party may file a motion to pre-file surrebuttal testimony. The motion shall be filed after any rebuttal testimony has been pre-filed and shall provide the commission with good cause, if any, as to why the party should be allowed to pre-file surrebuttal testimony in the specific case. A date shall also be set for the pre-filing of surrebuttal testimony should the commission grant the motion. Should the motion be granted for good cause, the surrebuttal testimony may be pre-filed. If good cause is not shown, the moving party may not pre-file surrebuttal testimony. In making this motion, I'm not accusing any party appearing before the commission of abusing the use of surrebuttal testimony. I'm stating that since surrebuttal testimony is discretionary with the commission, its presentation should be scrutinized and approved or rejected on a case-by-case basis by using the methodology that I have proposed. I so move.
Hearing Commissioner Powers' motion, is there any discussion or comment?
Yes, sir. I would just comment further that we've had some rather long involved hearings in the past year and a half that I felt like I didn't hear new issues. I just heard the same thing over, and I even felt like some of it denigrated to just who got the last word or an attack on each other's parties. And I just think there needs to be sound reasoning for surrebuttal testimony to be presented. Thank you.
Thank
Mr.
you,
Chair.
Commissioner Powers. Vice Chair Belzer?
Thank you. I think that Commissioner Powers, I respectfully appreciate your position and your motion. However, I am going to disagree with it today. I think that this matter really starts with the filing of a lot of times the filing of the application and the completeness of what needs to be in the application. I think that in the regulation review that has been undertaken by our executive director and staff, along with advisory committee members, that is one of the things that is being addressed. I think what I've seen happen over the years is that an application is filed, perfunctory direct testimony is filed. It doesn't give a lot of reasoning necessarily, but a lot of generalities. And then once the interveners and other parties, based on their discovery and other discussions with the applicant, once they file their testimony. Then in rebuttal, we see the case in chief really being presented, and I think that that's backwards. And I understand what the case law in South Carolina says. I don't think that the case law envisioned basically turning the regulatory process around, and I think that's what's happened here in some instances. So I think that the process that we have now allows for completeness, because oftentimes there is significant surrebuttal due to the amount of detail that is being presented on rebuttal that should have been presented in direct, in this person's opinion. And so I think that the process that's been in place is somewhat been working. I don't think that, well, surrebuttal hasn't been filed in every case when a party has not needed to address new matters brought out. But unfortunately, where we see significant rebuttal and significant surrebuttal are in these large cases. I do like the fact that the parties have the opportunity to present fully their positions. I think that's very important. And I don't think that that there will be any streamlining of the hearing by reining in somewhat some of the surrebuttal, for lack of a better term. Reining in may not be the right one. I would like to thank the parties for their comments. There were some interesting comments that I think that as the commission and the parties go through rulemakings, if we decide to revise some of the regulations, I think that even some of these comments that came in today would be very helpful. But while I appreciate what the motion is intended to do, I respectfully will be voting no on it. Thank you.
Chairman Williams.
Commissioner Caston, you have the floor, sir.
Having listened to the motion and Vice Chair Belcher's comments, all very good and thought-provoking. Relative to, I guess, issues with applications that are incomplete or not complete, I agree that has been an issue, or at least expressed as an issue, and I do think that is something that needs to be really cleaned up and held by standard. That said, the way this motion reads, what I understood, was it would be on a case-to-case basis. And if there were opportunities or times when the applications felt like were insufficient and it did justify surrebuttal testimony, then that makes sense. But every hearing is not tied to an application of that magnitude. So I guess the point I'm trying to make is the motion as read would be viewed on a case-to-case basis, which makes a lot of sense to me. Because if the direct testimony is thorough and the rebuttal testimony makes the point desired, I concur that should resolve these issues. But that said, just my view on it. But I appreciate it.
Commissioner Caston, I think we may be having some connectivity issues. Some of your comments were not heard. I don't know. I think I understood the general nature and intent of your comments, but if you want to repeat them for the sake of the record, you're welcome to do so. I just wanted to let you know that some of your comments were not heard.
When hopefully all the poor ones were not heard then. Can you hear me okay now?
Yes, sir.
And I guess a synopsis is the motion as read, I believe, makes good sense in that we're talking about doing it on a case-by-case basis. Every hearing we've had has not involved a detailed application process that, was, I guess, inadequate, or accused of being inadequate. So just a blanket option to always do it regardless to allow Sarah Bubble, to me, seems actually inappropriate. But viewing it as stated in the motion, case-by-case basis, based on the merits, makes sense. And relative applications, I too agree, applications are not complete, failed, then I'm not sure we should have a hearing until it is. I think that things that are being addressed will be addressed maybe in regulations also as far as updates. Could you hear that?
Well, there's still some words that we didn't hear, but again, I think we understood the general nature I think we understood the general nature of your comments, sir. We did not hear every word, but I think at least I understood the general nature of your comments. Madam Court Reporter, were you able to transcribe his comments? Okay. Just so you know, Commissioner Caston, there are some words that the court reporter left out because she could not hear them.
I understand, and I appreciate it. Well, thank y'all very much for enduring that.
Yes, sir.
Mr. Chairman, may I clarify something?
Yes, ma'am. Vice Chair Belzer.
I did not mean to say that, if I did, that the applications are incomplete. I think the applications are being filed in accordance with the regulations, but I think that the regulations require, are not sufficient enough with where we are on cases, on big cases these days, and what needs to be in the applications. I think that, and that's where I think the work is going, is to beef up what is required to be filed. That's where I think we need to start, is with that regulation on what needs to be filed. The ones that are coming in, they're meeting the basic requirements of the regulation. It's just that I think we're needing more detail. This commissioner's opinion is that we need more detail in the application than what the regulations currently require. So I just wanted to clarify that if I stated that the applications were insufficient, they are not insufficient with the current regulations. I think they're lacking what some of us want to see in the applications. Thank you.
All right. Commissioner Powers, I'm happy to support your motion, sir, and I appreciate your leadership. All the commissioners know, based on their leadership experience, that it's easy to do nothing. I think the commission seeks to gain procedural efficiency, and I think that this is a step towards that effort. I understand that we're in the review process of our regulations and that there are going to be some changes made there. But I also think it's not a bad idea to have discussions like these to see if there are opportunities for improvement. And I have to echo Vice Chair Belzer's comments about the parties' comments and participation. I greatly appreciated the parties offering suggestions, not just on the matter of rebuttal, but gaining procedural efficiency overall. And so my hope is that as we continue to review how we conduct business here at the commission, that we will continue to improve and use the tools we have available to help us pursue excellence. So I appreciate your leadership in the matter, sir, and I'm happy to support your motion. All right, if there are no further comments, we'll vote. We'll start with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
No.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas,
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, that completes the utilities agenda for today. Moving on to our motor carrier agenda, we have two items that encompass Class C authority, items 1 and 2, and staff would recommend that those be taken together today. Item number 1 is the application of Open Arms Counseling Center Incorporated, DBA Open Arms Logistical Service. This is for Class C stretcher van authority. Item number 2 is docket number 2022-30-T, application of East Coast Transportation Services, LLC, for Class C charter certificate.
Is there a motion?
Chairman Williams,
Commissioner Caston.
I move that the commission approve the applications for Class C authority and item numbers 1 and 2 as listed by Mr. Butler.
Thank
So
you.
moved.
Thank you, Commissioner Caston. Hearing Commissioner Caston's motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams,
Aye.
Vice Chair Belzer,
Aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, items 3 through 10 on the motor carriers agenda consists of requests to amend various documents. Item number 1 is a request to amend Class C non-emergency certificate number 9202 to read My Ride SC LLC. This is the application of S&W Investments, Inc., DBA S&W Transport.
Is there a motion?
Mr. Chairman, I have a motion.
Commissioner Powers, you have the floor, sir.
Thank you. I move the commission grant the request of S&W Investments Incorporated doing business as S&W Transport to amend Class C non-emergency certificate number 9202 to read My Ride SC LLC.
Hearing Commissioner Powers' motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams,
Aye.
Vice Chair Belzer,
Aye.
Commissioner Caston,
Aye.
Commissioner Irvin,
Aye.
Commissioner Thomas,
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 4 is in docket number 2021-369T. We have a request from Wells Venture LLC, DBA College Hunks Hauling Junk and Moving to amend its tariff.
Is there a motion?
Chairman Williams,
Commissioner Caston, you have the floor, sir.
hopefully you can hear me. I
Yeah.
move that the commission approve the application of Wells Venture LLC doing business College Hunks Hauling Junk to amend its. The commission's proposed amendment to the tariff are reasonable. In addition, the Office of Regulatory Staff reports the company is in compliance with all commissions and regulations. Wells Venture is to file tariff incorporating the conditions made in the proposed tariff, changing the of the tariff bottom of each page to the date issued approving the amendment, and correcting contents include all sections of the revised tariff into correct pages. I so move. Could you hear that?
I'm being told no, and
Can I call in? Because I'm getting reverb and feedback also, Chair Williams.
yes, sir.
Okay, let me, excuse me.
Understand. How about now? Can you hear me okay?
Yes, sir.
Okay, let me redo that. Now I apologize.
He need,
I had to mute that phone. How's that?
Just log off Skype.
All right, can you hear me now?
Yes, sir.
Let's try it one more time, Chairman Williams, if that's okay.
It's quite all right. Please continue.
I move that the commission approve the application of Wells Venture LLC, doing business as College Hunks Hauling Junk and Moving, to amend its tariff. The commission finds the proposed amendments to the tariff are reasonable and justified. In addition, the Office of Regulatory Staff reports the company is in compliance with all commission rules and regulations. Wells Venture is to file a final tariff incorporating the amendments made in the revised proposed tariff, changing the date of the tariff at the bottom of each page to the date of the order issued approving the amendment, and correcting the table of contents to include all sections of the revised tariff into correct page numbers. I so move.
Thank you, Commissioner Caston. Hearing Commissioner Caston's motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
I vote aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 5 is in docket number 2021-329T. We have for commission consideration K&K Investments, Inc.'s DBA Apartment Movers, etc., and America's Best Moving Systems application to amend its tariff.
Is there a motion?
Mr. Chairman, I have a motion.
Commissioner Irvin, you have the floor, sir.
Thank you, Mr. Chairman. I move that the commission approve K&K Investments, Inc., doing business as Apartment Movers, etc., and America's Best Moving Systems request to amend its remaining tariff changes, specifically Rule 16B, Rule 16D, Rule 27, Rule 37C, Rule 39, and Rule 40. K&K Investments is to file a final tariff incorporating all of the amendments made in the revised proposed tariff. So moved.
Hearing Commissioner Irvin's motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Irvin.
Aye.
Commissioner Powers.
Aye.
Commissioner Thomas.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 6 is in docket number 2009-151T. For commission consideration is a request for approval, a revised bill of lading by Malzone Russell DBA Basic Moving.
Is there a motion?
Chairman Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you, sir. With regard to its request for approval of its revised bill of lading, I move that the commission direct Malzone Russell, doing business as Basic Moving, to meet the requirements of South Carolina Code Annotated Regs 103-159 by incorporating the point of origin, which is number 4, the name and address of the consignee receiver, which is number 5, declaration of valuation, number 6, COD shipment information, number 8, and the number of the bill of lading, number 11, and any other elements necessary to ensure compliance with Regulation 103-159. Basic Moving shall file a final revised bill of lading incorporating these amendments within 30 days of today's date. Furthermore, I'd suggest updating the language regarding personal items to read as follows. All small valuables, including but not limited to purses, wallets, jewelry, and coins, shall be locked and or safely secured at all times if they are to be moved by Basic Moving. Basic Moving may not be responsible for any loss of personal items due to the customer's failure to properly secure such items during a move. I so move.
Hearing Commissioner Williams' motion, is there any discussion?
Mr. Chairman,
Commissioner Powers, you have the floor, sir.
thank you. I would join in with Commissioner Williams' motion that she's made, which avoids what I call blanket liability coverage, which is, it seems to be that originally they wanted to have a situation where they could just deny liability under any circumstance based on whether or not things are locked up or safely secured. One of the 14 requirements of the bill of lading is liability insurance itself. I just feel liability can't always be denied. I can think of several situations where in the rush of a move, someone, even the movers picked up something that had been not locked or safely secured and is put on the truck, and the mover uses kids from whatever neighborhood or whatever school or wherever he goes, and they take something. He's still liable, and I think it needs to be clear that there's no such thing as some sort of denial of liability in a case, and I think this motion serves us well, and it allows, if there is a question or a lawsuit or something to go to court, I think they walk into the courtroom on an equal footing by the language saying may not, rather than giving basic moving the right to just deny liability.
Thank you, sir.
Chairman Williams?
Commissioner Williams?
Thank you. This was a challenging motion to work on, and Basic Moving initiated this application by indicating to the Office of Regulatory Staff that they wanted to clarify responsibilities of the moving company and the client regarding personal items in their bill of lading. This led ORS to instruct Basic Moving to file application with the Commission for approval. Upon review, the items listed in my motion were found to be missing from the bill of lading. But in addition, my motion includes the suggestion to this pro se applicant that they, number one, define the referenced personal items by offering greater clarity and specificity than initially offered. And number two, that they reflect both the responsibility of the client to lock their personal valuables and to the company to provide due diligence in their shipment. Thank you, Mr. Chairman. Oh, normally the Commission would not make such an editorial suggestion, but given that this element of the bill of lading was their primary request, I've chosen to make this suggestion a part of my motion.
Understood.
Thank you.
Thank you, ma'am. Any further discussion?
Mr. Chairman.
Commissioner Urban, you have the floor, sir.
Thank you, Mr. Chairman. And I would like to follow up just a moment and suggest that we, as a commission, might consider a standard approved bill of lading. As so many of these applications are coming from pro se litigants who have no lawyer, I think it would be better, rather than having to review each and every bill of lading on a case-by-case basis, if we could come up with a proposed form. We may need to open a docket to take testimony and evidence and comments, but it would simplify the process. It would also give us the opportunity, as Commissioner Powers has pointed out, to protect the public interest, because these are what the law calls really an adhesion contract. When you're handed this bill of lading on your moving day, it's a lot of this is potentially it's in fine print. Everybody's in a hurry to get going, load the truck, and that's not the best kind of environment to discuss contractual provisions that could be unfairly included and prejudice the moving party's rights. We don't want that to happen. We also don't, I think it would be good for movers generally to know what belongs in a bill of lading. And I did a little research. The federal regs have a standard bill of lading, and they go through their 14 points that have to be included. and some of them have to be included in bold print so that they're clearly it's clear to the moving party what they're agreeing to. So I would hope that we might go a step further and consider adopting a standardized bill of lading for South Carolina movers that are under our jurisdiction, and perhaps we can consider that at our next regularly scheduled business meeting or at some other appropriate place and time. Thank you, Mr. Chairman.
Thank you, Commissioner Urban.
Mr. Chairman.
Commissioner Powers?
Mr. Chairman, I would strongly agree with Commissioner Irving. I don't want to micromanage moving companies. And I think the real competition should be in pricing, not in certain requirements that are legal requirements and are under our regs. And I think that it'd be a good thing to take a serious look at. And I appreciate both his research and his wise counsel on this. Thank you.
All right, any further discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye on the motion.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 7 is in docket number 2021-332T. Armstrong Relocation Company, Charleston, LLC, has an application to amend its tariff.
Is there a motion?
Chairman Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you, sir. I move that the commission approve the application of Armstrong Relocation Company, Charleston, LLC, to amend its tariff with 2 amendments. First, in order to improve clarity, the tariff should be updated to reflect that any fees related to additional stops during the move shall only be applied to the customer when they are specifically requested by the customer. Second, I'd request that the flight carry fee be updated to include a list of costs for each additional flight of stairs. Both of these points will help clarify the proposed rates. These amendments shall be incorporated into a final tariff and filed by Armstrong Relocation Company as a second revised proposed tariff within 30 days of today's date.
Hearing Commissioner Williams' motion, is there any discussion? Hearing none, we'll vote.
Mr. Chairman.
Yes, sir. Commissioner Urban.
Just briefly, and I appreciate Commissioner Carolee Williams' attention to detail on this particular contractual provision. But this, again, is another example where if we had a standard contract or bill of lading, we could specify with great precision what we mean by stairs and how that could be incorporated in a fair way for both the mover and the moving party so that it doesn't have to be interpreted or questioned during or after a move when the bill comes due. So again, this is another reason why we need a standard bill of lading, and I would hope that as we go through all these various changes that we're discussing today, we'll keep that in mind. Thank you, Mr. Chairman.
Thank you, sir. Any further discussion? Vice Chair Belzer?
I'm just, this motion pertains to the tariff, doesn't it? I'm a bit confused. This motion relates to the tariff, not a bill of lading, right?
I stand corrected,
Okay.
and you're right. And
I'm sorry.
perhaps we may need a standard tariff as well. That's just a thought because, again, these terms change from applicant to applicant. So it's just food for thought. Thank you, Madam Vice Chair.
Thank you for the clarification.
If there's no more discussion, we'll vote, starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 8 is under docket number 2021-345T. This is for commission consideration of Luxury Movers Moving Company LLC's application to amend its tariff.
Is there a motion?
Mr. Chairman,
Commissioner Powers, you have the floor, sir.
I move the commission approve Luxury Movers Moving Company LLC's request to amend its tariff.
Hearing Commissioner Powers' motion, is there any discussion?
Mr. Chairman,
Commissioner Powers, you have the floor, sir.
thank you. I'd like to add, this is another case, I think pro se, I'm a little disappointed in that I think we've given adequate time and adequate opportunity for a response as to why the increase should be done, and whether would give us a little more to decide on whether or not the increase is just and reasonable. It'd be very helpful to the staff if we had some sort of specificity as such as gas costs, labor costs, any sort of increase rather than because you have a lot of business. If someone's going to raise their price because they have a lot of business, that almost scares me or borders on some sort of price gouging, and we certainly don't want to go down that road. But this is one where the amount is right and is just and reasonable. But again, it would be helpful for more specificity. Thank you.
Commissioner Williams? Oh, all right. Any further discussion? Hearing none, we'll vote starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 9 is docket number 2021-358T. For commission consideration is the application of ABA Moving and Storage Incorporated, DBA Two Men in the Truck, to amend its tariff.
Is there a motion?
Chairman Williams.
Commissioner Williams, you have the floor, ma'am.
Thank you, sir. I move that the commission approve ABA Moving and Storage, Inc., doing business as Two Men and a Truck's request to amend its tariff.
Hearing Commissioner Williams' motion, is there any discussion? Hearing none, we'll vote starting with District 1. Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 10 is in docket number 2021-353T. This is a request of the South Carolina Tariff Bureau Incorporated to amend its South Carolina Tariff number 7.
Is there a motion?
Mr. Chairman, this is Commissioner Thomas.
Commissioner Thomas, you have the floor, sir.
Thank you. I move that the commission grant the application of South Carolina Tariff Bureau Incorporated to amend South Carolina Tariff number 7, canceling the South Carolina Tariff number 7 and replacing it with South Carolina Tariff number 8. In addition, I request that the South Carolina Tariff Bureau investigate whether the 60 cents per pound valuation referenced in Rule 2 and Rule 9 should be reevaluated in the next tariff update. So moved.
Hearing Commissioner Thomas's motion, is there any discussion? Hearing none,
Mr. Chairman.
Commissioner Thomas, you have the floor, sir.
Thank you. I'd just like to thank the South Carolina Tariff Bureau for updating this information. The document's about 27 pages long. And given that household movers are handling people's personal items, I'm sure it's a difficult business and it's hard to keep customers happy. And I've noticed that when we at the PSC conduct hearings to qualify new movers, we tend to have a lot of questions of a similar nature for the different applicants, much as we have seen here today in our discussions. And I think to the greatest extent that all parties can work together to formalize standard documents, it would be better for customers. I would like to encourage the moving industry, the South Carolina Tariff Bureau, the ORS, the PSC, and attorneys that work with the moving industry to continue to work toward more standard contracts. To me, that'd be something like realtors have a standard contract, and all realtors around the state use that same contract. That's all I have, sir.
Thank you for your comments, sir. Any further discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
I vote aye.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
I vote aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, item 11 is a request for an extension. We have the request of C&J Transportation LLC for an extension of time until May 1st, 2022 to comply with commission rules and regulations.
Is there a motion?
Chairman Williams, Commissioner Caston, I'd like to make a motion.
Commissioner Caston, you have the floor, sir.
I move that the commission grant the request of C&J Transportation LLC for an extension of time until May 1st, 2022 to comply with commission rules and regulations.
Hearing Commissioner Caston's motion, is there any discussion? Hearing none, we'll vote, starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
Aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Item number 12 is docket number 2016-405. We have a request for reinstatement of Class C taxi certificate number 9244 at the request of George C. McLean, Jr.
Is there a motion?
Mr. Chairman.
Commissioner Powers.
Thank you, Mr. Chairman. I move the commission carry over the request of George C. McLean Jr. for a reinstatement of Class C taxi certificate number 9244 until such time as the Office of Regulatory Staff provides a response to the applicant's request. So moved.
Hearing Commissioner Powers' motion, is there any discussion? Hearing none, we'll vote starting with District 1, Commissioner Williams.
Aye.
Vice Chair Belzer.
Aye.
Commissioner Caston.
Aye.
Commissioner Urban.
Aye.
Commissioner Thomas.
Aye.
Commissioner Powers.
I vote aye.
Chairman Williams votes aye. The ayes have it. The motion carries.
Mr. Chairman, other members of the commission, that does complete our motor carriers agenda and indeed all agendas before the commission for business today.
Thank you, Attorney Butler. Ladies and gentlemen, enjoy the rest of your day. We are adjourned.